Okay, class, this is going to be your test only. And so I'm going to start with 220 jury charge and some proper names that come out. You have Mr. Rich, Ms. Manx, Mr. Wright, Oklahoma Department of Corrections, and that's it. Okay, so this is going to be your test number 1, 220 for 5 minutes. All right, now, Mr. Rich, I would ask you to step down at this time and have a seat in front of the bar if you would. You have served as the alternate juror in this case, and it appears there will be no further need for your services. You have now completed your duties as a juror in this case. Now you are discharged with the thanks of the court. The question may arise whether you may now discuss this case with the lawyers, the defendant, or other persons. For your guidance, the court instructs you that whether you talk to anyone is entirely your own decision. It is proper for others to discuss the case with you, and you may talk to them at your own discretion. If you talk to them, you may tell them as much or as little as you would like about your thoughts in this case. If any person persists in discussing the case over your objections or becomes critical of your service either before or after any discussion has begun, please report it to me immediately. Thank you very much for your attention during the course of the trial. You are excused, and I will ask the bailiff to give your card back. You may advise the jury commissioner that I am excusing you for the rest of the week. Now that you, ladies and gentlemen, have submitted your verdict in this case, your duties are finished. I do have one final instruction to read to you, and then you are discharged with the thanks of the court. Now that you have returned a verdict of guilty, as charged in this case, it is up to me to pronounce sentence. The court finds that the jury obviously believed Ms. Banks, or you would have been unable to return a verdict of guilty. My recollection of her testimony was that it was not incredible, and because of that, the court is to some extent going to rely on her testimony in terms of the sentence in this case. For the record, I am not considering at all in my sentencing of Mr. Wright the first and second felony prosecutions and convictions, since it is my understanding those have been set aside in Oklahoma, and for purposes of this trial, they were not considered as part of the defendant's prior record. The third felony prosecution, I would note, occurred in 1979, which was certainly a long period of time ago. What is of greater concern to the court in terms of the sentence in this case is the fourth felony prosecution, in which Mr. Wright was found guilty of rape, deviant sexual intercourse, and of being a habitual criminal. I understand that the habitual criminal finding may well have been based on the prior conviction in Oklahoma, which I am not considering, as I just mentioned a minute ago. What I am really concerned with and what I am looking at is the violent nature of that crime. The defendant in this matter was paroled from the penitentiary on July 1 of 1987 and apparently was arrested and incarcerated within a very short period of time, that being February of 1988. What I'm very concerned about in terms of Mr. Wright's dangerousness is that this happened so very shortly after his release from incarceration, and that he was arrested on this case, frankly, I guess, by the victim essentially and her family. Those remarks are based upon her testimony. This was an extremely frightening situation for her. It occurred in the late hours of the night, and she was there with her infant child. The child was threatened, and she was threatened. There was a sawed-off shotgun used, and all of this occurred in her home, which under the law is described as a dwelling. Based upon that, the fact that the defendant had barely been out of incarceration at the time of the commission of this offense, and that it was such a violent offense as was his fourth felony prosecution, the court feels that Mr. Wright is an extremely dangerous human being, and it appears quite likely that any attempts at correction have not been fruitful. Sentencing to the Department of Corrections is mandatory, of course, but more so in the aggravated range. Because of the violent nature of this offense, the threats made both to Ms. Manx and the threats toward her child, and the fact that it occurred in her home late at night and involved two people essentially going through her home searching for money and other valuables that could be turned to cash without a great deal of trouble, and that Mr. Wright, according to Ms. Manx's testimony, was the person who was making these violent threats and was not doing the searching per se, is going to be directly responsible for pronouncing a very stiff sentence on Mr. Wright. The court is going to sentence Mr. Wright to 14 years in the Department of Corrections on count 1, which is the aggravated robbery count. Now, with regard to count 2, the second-degree burglary of a dwelling, the court feels that consecutive sentencing is allowable under the habitual criminal law, but I will sentence Mr. Wright concurrently to 6 years on count 2. With regard to count 3, the felony assault count, I am going to call upon the habitual criminal statutes and sentence Mr. Wright to an additional 15 years concurrently with counts 1 and 2. Further, the court will give Mr. Wright credit for pre-sentence confinement of 203 days and credit for good time on the pre-sentence confinement of 203 days. Ladies and gentlemen, I wanted you to witness the sentencing procedure in this case for your benefit. I will now give you your final instructions, and then you will be excused. The question may arise whether you may now discuss this case with the lawyers, the defendant, or other persons. For your guidance, the court instructs you that whether you talk to anyone is entirely your own decision. It is proper for others to discuss the case with you, and you may talk with them using your individual discretion. If you talk to them, you may tell them as much or as little about your deliberations or the facts that influenced your decision as you like. If any person persists in discussing the case over your objection or becomes critical of your service either before or after any discussion has begun, please report this. And then you've got your 200s. And so we have your 200 number 1. Proper names, you have sexual exploitation of children, sexual abuse in the first degree, endangering the welfare of a child. This is 200 number 1 jury charge for 5 minutes. Good luck. Members of the jury, the evidence in this case has been completed. In a moment, I will read you the law which you must apply in order to reach your verdict. But first, I want to mention a few things that you need to keep in mind when you are discussing this case in the jury room. It is my job to decide what rules of law apply to the case. While the lawyers may have commented during the trial on some of these rules, you are to be guided by what I say about them. You must follow all the law as I explain it to you. Even if you don't understand or disagree with the reasons for some of the rulings, you must follow them. No single one of these instructions states all of the law which must be applied. You must take these instructions and consider them all together as a whole. At times throughout the trial, the lawyers made objections to the questions asked by the other side and also to the answers of some of the witnesses. Do not draw any conclusions from these objections or from my rulings on the objections. These only related to the legal questions that I had to determine and should not influence your thinking to any degree. The arguments, statements, and objections made by counsel to me or to each other, and the rulings and the orders made by me and the remarks made by the court during the trial and not directed to you should not be considered by you in arriving at a verdict. The court did not, by any words uttered during the trial, and I do not by these instructions give or intimate or wish to be understood by you as giving or intimating any opinion as to what has or has not been proven in this case, nor as to what are or are not the facts in this case. During the course of the trial, you received all of the evidence that you may properly consider to decide the case. Your decision must be made by applying the rules of law which I give you to the evidence presented at trial. Neither sympathy nor prejudice should influence your decision. If you should decide that the prosecution has proved beyond a reasonable doubt that the defendant has committed the crime as charged, it will be my job to decide what the punishment will be. You should not try to guess what the punishment might be. You should not try to guess at all the degree of the punishment. It should not enter into your deliberations at any time in this case. Finally, you should consider all the evidence in the light of your observations and experience in life. The defendants are charged with committing the crimes of sexual exploitation of children, sexual abuse in the first degree, and endangering the welfare of a child. The defendants have pleaded not guilty. The information is a mere accusation against the defendants, and it is not in itself any evidence of the guilt of the defendants, and no juror should permit himself or herself to be influenced to any extent, however slight, against the defendants because or on account of the filing of such information. Every person charged with a crime is presumed to be innocent. This presumption of innocence remains with the defendants throughout the trial and should be given effect by you unless after considering all of the evidence you are then convinced that the defendant is guilty beyond a reasonable doubt. The prosecution has offered in evidence conversations, statements, or declarations claimed to have been made by the defendants to the police. The prosecution has submitted these in the belief that they should affect your verdict. But these conversations, statements, or declarations may not be considered by you unless you first determine and decide that the defendants then being in the custody of the police made them knowingly, intelligently, and voluntarily. I do not mean that you are to consider only the formal police custody after the arrest and booking. By the use of these words, I mean at any time when the defendants were actually in the physical control of the police, and this you are to determine by the surrounding circumstances. There has been evidence presented in this case that the defendants have been previously convicted of a crime. The fact that the defendants have been previously convicted of a crime or have committed an immoral act is not proof of their guilt in this case. You may consider these prior convictions only on the question of the degree of credibility of the defendants, which means the degree or extent to which you will believe their testimony. You may consider the defendant's previous conviction only in deciding how much you believe their testimony. You may believe their entire testimony despite their records. You may decide what testimony to believe. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. You may take into consideration each witness's knowledge, motive, state of mind, demeanor, and manner while on the witness stand. You may take into consideration the witness's means of knowledge, ability to observe, and strength of memory. You may take into consideration any relationship each witness may have to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. You should take into consideration all the facts and circumstances shown by the evidence which affects the credibility of the witness's testimony. You may believe all of the testimony of a particular witness, part of it or none of it. You have heard witnesses who have testified as experts. You are not bound by the testimony of experts. Their testimony is to be weighed as that of any other witness. It is entirely your decision to determine what weight shall be given their testimony. The mere number of witnesses appearing for or against a certain proposition does not, in and of itself, prove or disprove that proposition. The burden of proof is upon the prosecution to prove to, and then we have your second 200 jury charge, proper names. State of Georgia versus Sherry Lynn Walker. Georgia, Sherry Lynn Walker. County of Cobb, State of Georgia, Joe Henry and Linda Graham. This is going to be 200 jury charge number 2 for 5 minutes. Ladies and gentlemen of the jury, you're considering the case of the State of Georgia versus Sherry Lynn Walker. Whenever during the course of this charge I use a masculine pronoun, i.e. his, I intend it to include all the feminine gender unless the context in which the pronoun is used requires a different connotation. The defendant in this case has been indicted by the grand jury of this county of the offense of criminal solicitation. It comes to you by way of a true bill of indictment. It reads as follows: in the name and behalf of the citizens of Georgia, charge and accuse Sherry Lynn Walker of the offense of criminal solicitation that said accused in the county of Cobb, state of Georgia, on the 4th day of December 1991, did unlawfully with intent to engage another person in committing a felony, to wit murder, did solicit and attempt to cause that person, Joe Henry, to kill and murder Linda Graham, contrary to the laws of said state, the good order, peace, and dignity thereof. To this indictment, the defendant has entered a plea of not guilty, and this makes the issue which you have been selected, sworn, and impaneled to trial. Ladies and gentlemen, I caution you that the fact that this accused has been indicted by the grand jury is not evidence of her guilt. You should not consider the indictment as evidence or implication of guilt. Neither is the plea of not guilty to be considered as evidence. I charge you that this defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in her behalf. This presumption surrounds her and protects her until it is overcome by the state with evidence which is sufficient to convince you beyond a reasonable doubt as to the guilt of the accused. I charge you that no person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt and to a moral and reasonable certainty. I charge you further that the object of all legal investigation is the discovery of the truth, and the burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. I charge you also and further that there is no burden of proof upon the defendant whatever, and the burden of proof never shifts to the defendant to prove her innocence. I charge you, however, that the state is not required to prove the guilt of the accused beyond a reasonable doubt, all doubt, or to a mathematical certainty. Moral and reasonable certainty is all that can be expected in legal investigations. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or contrary notion, but a doubt to which a man may be given arising from a consideration of evidence, the lack of evidence, a conflict in the evidence, or a combination of those. If after giving consideration to all the facts and circumstances of this case, ladies and gentlemen, your minds are wavering, unsettled, unsatisfied, then that is a doubt of the law and you should acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. I charge you that if the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. I charge you further that you are made by law the sole and exclusive judges of the credibility or the believability of the witnesses, and it is for you to determine what witness or witnesses you will believe and those which you will not believe if there are some you do not believe. In passing upon their credibility, you may consider all the facts and circumstances of the case, the witness's manner of testifying, their intelligence, their interest or lack of interest, their means and opportunity for knowing the facts to which they have testified, the probability or improbability of their testimony and of the facts to which they have testified. And you may also consider their personal credibility insofar as it may legitimately appear to you from the trial of this case. Now, I charge you that if upon consideration of the evidence in this case, you find that there is a conflict in the testimony of the witnesses or a conflict between witnesses or one witness, it is your duty to settle this conflict if you can without believing that any witness has made a false statement. If you cannot do that, then it becomes your duty to believe that witness or those witnesses you think most entitled to believe. It is for you alone to determine what testimony you will credit and what testimony you will discredit. I charge you further, ladies and gentlemen, that to impeach a witness is to prove such witness is unworthy of belief. I instruct you that a witness may be impeached by a disproving of the facts to which the witness testified or by proof of general bad character. I charge you that if a witness shall swear willfully and knowingly falsely, that witness's testimony shall be disregarded entirely unless corroborated by circumstances or other unimpeached evidence. Now, it is for you, the jury, to determine whether or not a witness has been impeached and determine the credibility of such witness and the weight his or her testimony shall receive in the consideration of this case. I charge you that you are the judges of both the law and the facts. I charge you further that this defendant is charged. Okay, and so that concludes your test, you all. Have a great day, you all.